Yes.
Yes.
Okay, good.
Okay.
All right. So, my name is Caitlin Costello. I'm an immigration lawyer at the firm of Palladino, Isbell, and Casaza, located here in Philadelphia. I'm going to give an overview of the citizenship naturalization process and requirements, and then feel free to ask me questions, and feel free to stop if something isn't clear too. Anybody in the United States, who's born in the United States under the Constitution is a U.S. citizen by law says, and it's part of the Constitution. So anybody who's here and who's born in the United States is a U.S. citizen. Anybody who's not born in the United States, either they can become a citizen through naturalization, or through acquisition when they became a citizen by birth through their parents by some way, or because they derived citizenship generally through their parents. And those are three different ways. So if we're talking about applying to become a citizen, the first thing to look at is to see if anybody is already a citizen under the law. So, for example, if somebody's here just as an example, if somebody's here like as a teenager, a child, and they are living with their parent, and their parent becomes a U.S. citizen, they meet some certain requirements, that child automatically derives citizenship through their parents. So somebody cannot naturalize if they become a citizen by law. So that's the first thing to look at, is to see if there's any ways that somebody acquired or derived citizenship through their parents. But moving past those eligibility issues, there are requirements for naturalization. If you have to be at least 18 years old when you apply, you have to have been lawfully admitted as a permanent resident. So you got your status lawfully, your permanent resident status for lawfully. And generally, you have to be a citizen for at least 5 years before you apply for naturalization. Some exceptions to that. And under the general, you have to show that you've been continuously residing in the United States for 5 years, and that you've been physically present at least 3 months out of the 5 years before you file the naturalization application. You also have to show that you are living at least 3 months in the state where you're applying. So in Pennsylvania, for example, before you file the application. You have to show that you are a person of moral character. So I'll talk more about that, but you have to show that in those past 5 years, you've been a person of good moral character. And then you have to obviously understand the U.S. Constitution and say that you will agree to those principles and deals.
Caitlin, you're breaking up. Caitlin, can you hear me?
Caitlin?
Caitlin?
Caitlin, you're breaking up.
Okay.
I don't think she's hearing. Caitlin.
About the
Caitlin, if you can hear us, your audio is not very well. It goes in and out.
Can you hear me better like this?
Yes.
Much better.
Can you hear me better?
Yes, yes. If you can go over what you said a few minutes ago, that would be great.
Yes.
I can hear you.
Sure. Yeah. Okay. So just to go over the last couple points, you have to show that you respect the Constitution, that you're able to read, write, and speak basic English, subject to some requirements, that you're able to pass a civics test, and that you will be able to take an oath of allegiance to the United States. Okay, the biggest one, well, actually, I will start with being lawfully admitted. So sometimes we run into cases where somebody got their green card, they were able to get their green card, but maybe there was an issue. So for example, somebody they have a family member here, and let's say they were a parent here, and their parent applied for them as their child, an unmarried child. Then they came to the US, and then they said, I'm going to apply for my spouse who's actually back in another country, and I want to apply for my spouse. Well, then they say, oh, actually, we got married back in the other country, and now I want to apply for them. Well, USCIS is going to say, hold on a second. If you're married now and you came in as an unmarried child, that was not, you weren't lawfully admitted. So sometimes people run into issues with that, and that's one thing to look out for, because even if you got your green card, one of the requirements to naturalization is that you had to get that status lawfully. And if there was an issue with the application, sometimes those things can come up. Okay, in terms of the good moral character requirement, there is what we call a look back period, which is the time requirement that you're looking back when that you have to show that you're a person of good moral character. If you're applying under the general naturalization application, it's 5 years. Okay, so we look back the last 5 years and looked at your character those last 5 years. Usually, the things that cause issues are arrests. So if somebody has been arrested for a crime, obviously if they have been convicted of a crime, and then if they've served on probation during that time, and anything that has any criminal conduct or during that time. So those are the kind of things that they will ask about. Having an arrest or even a conviction alone doesn't necessarily mean that you can't naturalize. But generally, as a general rule, we often tell people that if you've had an arrest or conviction within the last 5 years, or you were on probation, to wait until that period is done and wait 5 years from that time to not run into issues. Although, sometimes there are explanations, and it doesn't mean that somebody is necessarily barred, but they will definitely ask about it. Even if you have an arrest that was longer, that was back, before the 5 year period, they can still ask you about it, and will likely still ask you about it, and they can still consider it, but it's a discretionary element. It's not within that 5 year period. Anytime anybody has been arrested in the United States, immigration will know about it. Doesn't matter if charges were dismissed. Doesn't matter if you got a diversion program. It doesn't matter if you completed everything, if they said that the record's been expunged. Nothing's ever expunged with immigration. Everything will come up on your immigration file. So anytime that the form asks, have you ever been arrested, you have to disclose those arrests and explain. That is usually the biggest one is good moral character. Again, if there's something that happened before that period, it's something that they can still consider, but it's an element of discretion. Okay. Okay. Let's talk about the English. So for most people, you have to be able to read, write, and speak basic English. You can't bring an interpreter normally to the interview for citizenship. It's not like other interviews. You have to do the interview in English and respond to questions, go over the information, and also do the civics test in English. There are exceptions for this. One of them is dependent on age. So if you're age 50 years and older and you've lived in the US as a permanent resident for 20 years, or age 55 and you've lived in the US as a permanent resident for 15 years, you don't have to show that you read, write, speak, and understand English. You still have to take the test, but you can use an interpreter to do the civics exam. If you're age 65 and older and you've been here at least 20 years, you also don't have to do the English requirement. And there's some exemptions also for the civics exam. The other exemption is for medical disabilities. So, for example, let's say you have you're an older person who has Alzheimer's, and they are not able to retain new information. They aren't able to learn English at their age. They might be able to get a medical exemption so that they don't have to take the test. They don't have to show that they can read or write or speak English, and they can get a medical exemption for all of that. They still have to file for naturalization. They still have to meet the good moral character requirements and all the other requirements, but they don't have to deal with the English portion of it if they're able to get a medical disability exception. Okay. Some of the other things that can come up in the good moral character, besides arrest, there are some things that would bar somebody from becoming a citizen potentially at any point. So I will kind of quickly go through them just so that you are aware of them. But one of them is certain types of crimes. If you were in jail with a sentence of 5 years or more, even if it's for multiple cases. If you're convicted of a controlled substance violation, if you gave false testimony under oath, prostitution, smuggling people, polygamy, if you were found to be a habitual drunkard, you committed adultery, 2 or more convictions for driving under the influence, failing to support your dependents. So like if you have children that you aren't paying child support for, all of those things can come up as issues in the naturalization context. If any of those might apply in your case, my advice would be to meet with an immigration lawyer to discuss whether it's a good idea to file for naturalization, because some people are clearly barred, and applying for naturalization might put them at greater risk. So sometimes the best thing to do is just not to apply. Somebody who maybe fraudulently obtained their green card also, maybe they're better off doing nothing. So if there's anything that is, come up in your case, always better to discuss it with an immigration lawyer that you trust and can give you advice specific to your case. The physical presence and continuous residence requirements I touched on briefly. They're a little bit technical, so I don't want to go into them too much. But basically, you have to be maintaining the U.S. as your residence, and you have to show that you've been physically present in the United States at least 30 months of the last 5 years. And you just have to look at all the dates. So it's very fact specific. Okay. An exception to the 5-year filing requirement is if you've been married to and living with your U.S. citizen spouse or you can apply for citizenship after 3 years of being a green card holder. The same is true as if you got your green card through VAWA and your spouse was a citizen. You can also apply based on the 3 years. And there are some exceptions too for people in the military. That is kind of an overview of all the requirements. I'm happy to answer questions or clarify things about anything about citizenship if anybody has questions.
Thank you, Caitlin. At this time, if you have any questions, you may raise your hand in the column. Raise your hand, and then you'll be called upon. You can unmute and ask your question. I do have someone that has a question for you, Caitlin. Patrice, are you ready to ask a question?
Hi, good evening. I wanted to find out in regards to the naturalization, is that related to Form N-400?
Yes. Okay. So I'll just briefly talk about the process. But when you apply for naturalization, you file the Form N-400. As you said, you can file that online now if you do make a USCIS account online, or you can file it by mail. Once you file the application, the next thing that will happen is that you will get a receipt notice. And then generally you will get a fingerprint notice for you to get fingerprinted. And then either they will, usually the next step is they will schedule you for an interview. And then you will go in, you'll take the test, go through your application, and either they will tell you a decision on the spot, or they could take additional time to make a decision. Yeah, I can get into kind of more about what happens after the interview if you'd like as well. But yeah, the form is the N-400.
Yes. And I wanted to ask, would they also have to file Form I-130 and I-485 along with N-400?
No.
Okay.
So the I-130 and the I-485 is the green card application. The I-130 is a petition for alien relative.
Okay.
So those are sometimes filed together, sometimes filed separately, but that would be how you would obtain permanent residence and how you would get your green card. The M-400 is just the naturalization.
Okay. Thank you. I do have a question. So I have a situation where my cousin has a HB1 visa, and now she wants to change that into a visitor's visa. What's the process, and what's the time limit or the time? How long does that take for the whole process?
Okay, so you're just asking about not naturalization, about
No, from
Okay.
from an HB1 visa to because she's done with school now, to a regular visitor's visa.
Okay, so school is an F1. Okay, and in any event, I will try. It's hard to give specific advice about some of these information.
Okay, that's fine.
But I will say just generally as a brief overview is somebody, if they're changing from one visa category to another, what they would do is file a change of status.
Okay, so I have another question from the chat. At what age can a child petition for their parent?
Sure. Yeah. So if a child is a U.S. citizen, they have to be 21 years old to petition for their parent, and they would be petitioning for a green card.
Okay. Do they have to be? They would have to be employed, correct? And not in school?
Not necessarily. So they have to provide what's called the affidavit of support. In that case, but if they aren't able to meet those support requirements, they can get a joint sponsor to supplement their income.
Okay. Some of the concerns that not concerns but questions that I'm hearing is that what if someone starts the application, their citizenship petition application now? Um, do you know if it do the time limits that it takes to get that done, and what assistance or resources is there for them if they're not able to pay the filing fees?
Sure. Yeah, good question. So right now, the so in Philadelphia, which is where we do the majority of our cases, I would say they're taking about 6 to 9 months for an interview from when you file to getting the interview. Sometimes it's even been a little bit faster than that. But generally, that's been how long it's taking approximately. It can vary a little bit from office to office, but and then after the interview, generally people get a. So what happens after the interview? Like I said, if they approve the application, the next thing you would get an oath ceremony notice in the mail, and then you would come back to take do a ceremony and take the oath of allegiance and get your naturalization certificate. In Philadelphia, they do that on a separate day. There are some offices that hold same oath ceremonies the same day that somebody has their interview. And then at that point, that's when you would become a citizen after you've taken the oath.
Okay. Okay, thank you. Tankawa, I am so sorry, I don't want to torture your name. You can lower your hands and ask the question. Go ahead. We're not hearing you if you're speaking.
Usman Tunka.
Yeah.
Can you hear me now?
Yes, we
Yes.
can hear you now.
Yeah, very good. So I have two questions. The first one may be related to naturalization. So if I understand very well, you stated that you have to wait 3 years if you have a green card to an American citizen to qualify for naturalization, correct? Am I understand
Yes.
that correctly? Okay, wonderful. So that's clear. And the last question might not be related to naturalization, but it is for somebody that has withholding and of removal and getting married to an American citizen. Do we need to open the case to qualify to obtain the green card, or what?
Yeah. Okay. So to the first question, so yes, and I will just clarify that you still have to be married to and living with that U.S. citizen spouse. It's not good enough if you're separated. You have to continue to be with that person to qualify. But to your second point, again, this is very case specific, but the general answer is that if somebody has withholding of removal and they're married to a U.S. citizen, you can't file a green card with USCIS because you have withholding of removal and the case is with the court. So you would have to, at some point, get that case reopened in order to apply for the green card.
And for the person with,
although there are some exceptions, but
good. We're good. And with the person with a green card, so how long within 3 years? When can you apply? Like 3 months before the 3 year end, or 6 months, or what?
Yeah, so you can apply 90 days before you've completed the 3 years.
Yeah.
Good. Thank you.
Sure. Also, I didn't answer the filing fee question. I forgot to answer that one. So the filing fee to file, if you file by paper, it's $760. If you file the application online, it's $710. However, based on the rules that came out last year, if you can show that your household income is less than 400% of the federal poverty guidelines, that's just available online, it's only $380 to apply. And if you're eligible for a fee waiver, you can pay you can file for free. Generally, to be filing for a fee waiver, you have to show you have, extenuating circumstances that you're not able to pay, that you're getting benefits, state benefits that are documented, such as food stamps, or that your income requirements are low enough that you don't have to pay the filing fees. So there is a way to apply for a fee waiver if you're not able to afford the fees.
Okay, thank you. And now there was a follow-up question to the child parent filing. How about the parent petition for a child age 40? Can a parent petition for a child over age 40 and over?
Yes, so there's different visa categories. Again, this would be for a green card, but so I will pull up. So every month, the government gives the visa bulletin based on when different categories can, not when they can apply, but when they can apply for a green card. So let's say somebody petitions for if I petition for my parent as a U.S. citizen, I can apply for them immediately. Same with a spouse or a minor child. But for different categories, they're subject to different limits that are set each year, or there's a certain limit that they give each fiscal year. And then each month they publish when somebody can apply under different categories. So a U.S. citizen who has an unmarried son or daughter, or a married son or daughter, those are two different categories. So let's talk first about unmarried sons or daughters of U.S. citizens. They are, for most countries, and there's some countries that are laid out differently, but now able to process applications that were filed in 2015, November of 2015. So you have to show that your case was filed before then to be able to apply for a green card now. If they were a married son or daughter of a U.S. citizen, they're now accepting cases that were filed before July 2010. So the short answer is yes, there's a way to do it, but there are, and those, it doesn't mean, each month it moves forward a little month. There's some months where those dates don't move at all. So there is a way to apply for them, but in some cases, the reality is it would take 10 years, 15 years, 20 years.
Wow.
The way.
Okay.
Yeah.
All right. I have another question. Thank you, Caitlin. Can someone with a green card file for citizenship if they owe child support?
That's a good question. So generally, I guess I would say it probably depends on when. If they continue to owe child support, probably not, because as I said, one bar is failing to support.
Yes, you did say that, yeah.
They're failing to support dependents. So, and it says, the language is willful failure or refusal to support dependents unless extenuating circumstances are established. Generally, in my practice, anytime that somebody has a child that they're not living with, I ask for proof that you've been financially supporting your child. I would say it would be a little bit fact dependent. Maybe if you're paying regularly now, but maybe you have some child support arrears, maybe then, or it wasn't willful, or, it would be a little bit fact dependent, but yeah, possibly.
Okay, thank you. So here's a question for you. With the form, I'm not sure what form form N400. The yes and no questions on the form, the additional questions, Do you know the meaning of taxes, or do you know the meaning of taxes overdue? And you don't know the answers to them. Can that cause you not to pass the N400 form?
Yeah, so one requirement to completing the good moral character requirements is that you are tax compliant, so that you have filed taxes at the very least within those five, the good moral period character period within those 5 years. So one of the questions on the form is, do you currently owe any overdue federal, state, or local taxes? And you have to put yes or no. So if you didn't file taxes, or you owe and you generally you're not going to be able to naturalize. At the very least, you have to show that you are on a payment plan and working on paying those taxes. If you just fail to file, you're not going to be able to naturalize, at least not honestly. And then the other tax question is, have you ever called yourself a non-resident alien or decided not to file or tried to avoid paying taxes? That would also be an issue.
Awesome. Now, do you practice just in Pennsylvania? Or do you extend to Delaware and New Jersey?
Yeah, we extend to basically everywhere. The thing that is more limited is in the immigration courts.
Okay.
Well, we can practice anywhere throughout the United States, but I would say generally I take cases like Philadelphia, New Jersey, New York, Baltimore.
Connecticut.
Sometimes.
Okay.
If the same for if somebody, for example, wants to hire me for an immigration case for a naturalization. If they want somebody to go to the interview, I'm not going to go to California just for the naturalization interview. So we can certainly file somebody's application, but the more tricky part is if somebody needs in-person representation for something. If you're filing for your spouse abroad, we never have to go to an in-person interview with anybody. So that we can do from anywhere. So yes, generally we'll handle cases from anywhere, but it depends a little bit.
Awesome. Thank you. Now, one of the concerns that I may have is if application is already in process for citizenship,
Sure.
and there's a change of government, can that affect the application that's already in process?
Yeah, good question. I can tell you historically, changes that are made so there are some changes that a president can make without congressional or support, and there's some changes that can make, but they have to go through a rulemaking process. I will say the last time that Trump was president, he tried to make changes to the naturalization procedure. And generally, when they make those changes, they are not retroactive, so they won't apply generally to things that have already been filed. They would be, forward looking, those kind of changes.
On new applications, okay.
Generally. But there were some changes again under Trump before that, for example, with asylum that were applied to any case. Didn't matter whether you had filed, it just mattered whether you were still hadn't received a decision yet in your case. So it depends a little bit. I will say generally with naturalization, if you apply today and they said, oh, you need to actually file this new form, or you need to pay this additional money, they can't change that. You've already filed, the case is in process. But that generally, I would not worry about cases that are already filed and in process for naturalization.
Okay. Thank you. Well, one of the other concerns that has been expressed is that, that in some homes there may be family members that are undocumented, but the children have citizenship. How can we prepare for those children who are minors who will get caught up if their parents are arrested to be sent back
Yeah.
home?
It's a great question. I mean, it's a long answer and it's complicated because it's a little bit dependent on what happens and what kind of changes they make and each individual's circumstances. But I would say generally a good thing to know is that somebody's here, let's say somebody's here without status, doesn't have any papers. They entered on a visa many years ago and they don't have any permission to be here. It's not like immigration generally can come and just take them and deport them in one day. They have to they do have rights to, again, there are some exceptions if somebody was given expedited removal at the border or some exceptions, but for somebody who just entered on a visa, for example, doesn't have status, they can't just come and say, okay, we're deporting you. They have due process rights to be heard in front of an immigration judge. That means they have to go in front of an immigration judge. They can say if they have any fear of returning to their country, et cetera, et cetera, et cetera. That process, at least currently, does not happen quickly. It takes time. So it's not something that somebody can just get picked up unless they already have a removal order against them. That's different. But if somebody here without status isn't just going to get sent back in one day. So that's one thing to know. Generally, most people too, if they're arrested by ICE, again, most are eligible to request a bond from an immigration judge to ask to be released while their case is pending. So it's important to know that even if you're here without status, you do normally have rights and are able to pursue them. Let's say somebody is here and they have children and they have a removal order. That person, however, can still be removed. It doesn't matter if your spouse is a citizen, it doesn't matter if your kids are a citizen. If you have a removal order against you, it's important to know too that you still can be deported in those situations. And those people are very much at risk because they could be deported today. It doesn't matter who's president. So those people definitely are at great risk and should consult with somebody to see if there's any options available to them. In terms of the children, I think, some organizations have been advising people to have a plan in place for if that happens, what you would, have a power of attorney if you're, what your kids, where your kids would be if you're the only person responsible for them, and then just to have a plan in place in those cases. So again, it's very dependent on somebody's circumstances, but that's kind of just some general information about what would happen in those circumstances.
Okay, thank you. Do we have any other questions for Caitlin? Jody, do you have any questions?
I do not. I do not.
Okay, let me see what leaders I have in here. Barbara Wilson, do you have any questions for Miss Caitlin?
No, not right now.
Okay. Helen May Beatty, do you have any questions you heard amongst your community? Nope. Okay. No other questions. Oh, here go Osami. Osmain. You can go ahead with your question, Osmain. Unmute and ask a question.
Can you see here?
Yes, we can hear you now. Yes.
Oh, very good. Excellent. Okay, so this is my last question. I think I asked you already. So my last question, Attorney, is that do you see any change happening in the registry, the date of the registry?
Say it again. Any change?
Do you see any change with the registry date?
Registration? Say it again. I couldn't hear what you were saying.
I think he's stuck.
He's frozen, it looks like. If you can hear us, you can type your
Those that have been
question.
here, those that have been here before 1972, automatically
Ah,
would qualify for green card.
Oh,
you mean like under the previous amnesties? And
Correct. Yes.
so that would have to be something that would be passed by Congress. You know, it's something that they've been trying to pass for the last 20 years, I would say. And even in better times, they weren't able to pass it. So, I'm not crossing my fingers.
Okay. All right. Thank you.
Yeah.
all right. I have a couple more questions from the chat. The first one is, at what age does a child need to start filing taxes to start petition for a parent?
So generally, I mean, I'm not a tax expert, but generally, anytime that your income has passed the income requirements, which or they publish them each year, but then you have to file taxes whenever you're earning any income that passes the threshold of your income requirements. In order, when anybody files an affidavit of support for anybody, be it a parent or anybody else, you have to show your taxes for at least the last three tax years.
Mm-hmm. Oh, okay. Okay, Tazi. All right. Another question that I have is, someone was on a F1 visa but got terminated for an unauthorized work. My screen's moving. But now married to a U.S. citizen. They're asking what are their chances of getting a family-based citizenship.
Again, it's hard to answer case-specific questions, but I will kind of give a general overview, which is if somebody entered on F1, let's say they entered on F1 and there were no issues, but they overstayed their visa and they got married to a U.S. citizen. Yeah, generally then they, assuming there are no other issues, could get their green card based on marriage. The issue that can come up sometimes is if they believe that there was fraud in obtaining the visa. So that's where an issue could potentially come up if there was a misrepresentation made at some point.
Okay.
In which case they would have to get a waiver. But yeah, that's kind of what the risk might potentially be. I would say definitely consult with a lawyer.
Okay, thank you. And we have someone here that asking a question. As a notary, how can she assist those clients in need of citizenship?
So it's tricky for me to answer. I mean, anybody without a law license can't give any legal advice.
Mm-hmm.
So I would definitely just caution, sometimes obviously people need help with interpretation and completing information, and that's understandable. But people have sometimes complicated immigration histories, and as lawyers, at least if we're doing our job properly, we should be not just filling out forms, but screening people, making sure that they're actually eligible,
Okay.
advising them at the same time. So, yeah, that I would say, yeah,
Okay.
it's hard for me to answer that question.
Okay, thank you. Another question that we have.
So let me ask this. This question was sent directly to me. I think they wanted to post it in the group.
Okay.
The N400 form, that's for the citizenship, correct?
Correct.
Okay, so their question is, if you have filed your N400 and your child is undocumented, but you have a change of status filed, would that affect your outcome?
That the child has filed a change of status, I'm guessing. I mean, if I'm filing for naturalization, the status of my family members isn't going to affect my application is the short answer. Unless like I helped somebody, enter the US illegally, helped to smuggle somebody, something like that. But if you're living with somebody who's undocumented, that doesn't affect your naturalization application.
Okay, thank you. Go ahead, Teresa. There's another question.
Yes. Does your firm handle re-entry requests?
So I'm assuming there's some for permanent residents to re-enter if they've been outside the US for too long, and yes.
Probably, yeah. Donna, does that answer? Is that what you were looking for, Donna? Donna? Okay. So there's a question here in the chat. What if your brother filed for you, but due to disagreement, he refuses to do the affidavit of support? Can they get a co-sponsor and file without him? The green card should have been issued since 2012. How am I to move forward with their petition? The I-130 was approved in 1999.
Oh.
Ouch.
So generally, when you if somebody sponsors you, and that person is still alive, they also have to sign an affidavit of support as the petitioner. Even if you have a joint sponsor, they would still have to sign an affidavit of support as well. I cannot answer more specific case questions individually, but that would be the general.
Okay.
Yeah.
Well, Caitlin, you have been amazing.
Oh.
Thank you. Do we have any more questions from the chat? Hearing none. Caitlin, I'd like to take this opportunity. Joanne, do you have any other questions? Jody?
I don't, but I will say this. I've posted Caitlin's contact information in the chat as well as mine. If you guys have any questions, as she has said multiple times, every case is different. So maybe your case might be something that, that needs additional information, or you need a one-on-one. So please reach out. And I'm here as well. And also, Teresa, if you guys have any questions, yeah.
And just post Caitlin's information again for those who came in later. And I'm posting your information again. Thanks for joining us, everyone. We appreciate having you here. Look out, we'll be having more sessions like this. Caitlin, if there are any changes come up, can you share with us anything that we should know as a community?
Sure. I mean, there will probably be, unfortunately, many changes in the coming weeks.
Oh, yeah.
So we'll try to stay on top of them. But yes, we will see what's to come, and we will continue to represent our clients as best as we can, and just know that you do have rights even if you don't have status here. So yeah, thank you very much for hosting.
You're welcome. Thanks. There'll be more in the future. And if anything happens to your family, we, the leaders of the immigrant community, are very much here to assist you and your family members. Just reach out. The main point of contact is the New Sanctuary Movement, and Joanne will branch it out to those of us who need to know. But your information is safe and secure with us at the New Sanctuary Movement. Thank you for joining us tonight. Caitlin, thank you so